going. It sounds like some other people may be joining us, but it sounds like we have a fair group of participants already. Welcome, everyone, to the frightening state of California employment law. We are pleased to be here with you. Welcome, everybody. Just a couple of quick housekeeping matters before we get started. As some of you know, Holland & Hart is a full-service firm that has offices in 9 different states and Washington, D.C. Who you're seeing today is a part of our California licensed labor and employment group team. We have additional attorneys who support clients with needs in California as well. Now, on a different note, you will see there's a Q&A panel on the side of your screen. We welcome all of your questions. We have tried to divide various subjects so you all are not sick and tired from the same person talking to you for the full hour. But we do welcome questions, and we plan on answering them as they come in to the extent possible. I don't want to discourage you from submitting questions, though. Even if we don't get to them, we will try to follow up with you and answer those questions via email to the extent possible. So please go ahead and submit your questions. And with that, I will turn it to my colleague, Dave Williams.
Thanks, Dora. Hi, everyone. I'm David Williams. I'm an associate in Holland & Hart's Salt Lake City office. Though before I came here, I practiced for a few years in California. So I'll be covering a few notable law and regulation changes. So this has been a very busy session for the legislature. Governor Newsom has signed a lot of new laws into effect. So many that we can't cover all of them here or even begin to cover all of them here. So we've selected a few highlights that are going to be generally applicable to many of the attendees here. Now, some notable things that I'm not covering are industry-specific changes. So, you know, depending on your industry, there may be some other laws that I'm not touching on here that will affect your California operations. So I only have a few minutes. So again, I just picked a few that are generally applicable. So this is divided up into 2 categories. First are laws that are in effect now, many of which went into effect in mid-September and had compliance deadlines that have already passed. So we hope that you're aware of these, but I'll just run over a few of them just in case. So first will be the COVID-19 supplemental paid sick leave. This is AB 1267. So this applies to employers with 500 or more employees, and it's going to require you to provide up to 80 hours of supplemental COVID paid sick leave. Now, this bill was meant to fill some gaps left by the federal relief that was passed earlier in the spring. It started out with an executive order from Governor Newsom back in April that imposed very similar requirements to this law for food sector workers. But this bill covers all other sectors and incorporates that executive order. So, you know, if you're in the food sector, you should have been supplying this supplemental leave since April 16th. For everyone else, again, with 500 or more employees, you should have started supplying, giving supplemental paid COVID sick leave on September 19th. And if you have questions, the Labor Commissioner has published some helpful FAQs for this bill. So next, another COVID one, the rebuttable presumption of workers' compensation coverage for employees with COVID-19 has been extended. This is SB 1159. So again, this was originally an executive order from Governor Newsom, but it expired in July. The executive order did. So this presumption has now been extended, and it means that there's a presumption of workers' compensation coverage for employees who contracted COVID in the workplace. This bill requires you to conduct a retrospective review and compile data regarding positive tests from July 6th to September 16th. And you were supposed to report those to the Workers' Comp Administration by October 17th, so hopefully you've done that. And then on a rolling basis since September 17th, you have to be active in reporting positive tests to the Workers' Comp Administrator. And again, there are some helpful FAQs on the DWC website. So the last one I'm going to mention.
Hey, David.
Sure.
I just want to chime in here, and the group of panelists will be chiming in every once in a while. You know, I think we give California a ton of grief for all of the crazy things that they pass and enact, and this rebuttable presumption might be one of the only sort of employer-friendly things that you have in California, in a sense that it eliminates the question of whether, you know, we as an employer might be on the hook for negligence or these other things by putting it into the workers' comp structure, where that's the exclusive remedy, arguably, if it operates like every other workers' comp injury. And so this could actually provide employers protections that otherwise may not be there, and maybe prevent some of these claims that we're starting to see around the country, even in Utah, by employees that say, hey, employer, you were negligent in the workplace, and I want, $1 million. So anyway, I wanted to give one little ounce of credit, I think, to Governor Newsom, because some of the other things don't make any sense, but this one actually provides some clarity, and perhaps, we'll see how it plays out, but perhaps this actually provides coverage for employers in a way that is more protective than a lot of other states. So thanks for letting me jump in.
Yeah, great. Thank you, Brian. Yes, and so again, go ahead, Dora.
I'm sorry. I was going to wait until the end, but since we decided to start jumping in, one quick point on the COVID supplemental paid sick leave. I just wanted to remind folks that that particular bill also comes with obligations to reflect the available paid sick leave on employees' paychecks, in a manner very similar to, in fact, identical to the one that you guys are currently required to reflect for the regular paid sick leave. So that needs to be on employees' paychecks. Please make sure you include it, because as we all know, those are some of the most commonly brought claims in California. They don't have all the info on paychecks that ought to be there. So, okay, I'll jump off. Sorry, David, for the multiple interruptions.
No, please. That's very helpful. Thank you, Dora. So the last one that is already in effect that I'm just going to briefly mention, because Greg Salin is going to cover this one in depth. This is AB 2257. This has added some exceptions and other things to the notorious AB 5 that delineates between employees and independent contractors. So a little teaser there. Greg's going to cover that later. So the next category is laws that are going into effect on January 1st. Again, there are a lot more of these than I can cover today, so I just selected a few highlights. We'll start with one more COVID-related one. This is a required COVID-19 exposure notice to employees, AB 685. So this establishes fairly stringent recording and reporting requirements when employers receive notice of a potential COVID-19 exposure in the workplace. Specifically, employers are required to provide employees with a written notification within 1 business day of receiving notice of a potential exposure. And then in addition, if there's an outbreak is defined as 3 or more cases within a 14-day period. You have to report that outbreak to the local health department within 48 hours. And finally, this bill increases Cal OSHA's enforcement authority related to COVID-19. So with that, we'll move off of COVID for a moment. AB 973. This is required reporting of race and gender. So this applies to private employers with 100 or more employees, and to those who are already filing the Federal Employer Information Report, that's EEO1. So now you're going to also have to submit a pay data report to the Department of Fair Employment and Housing that states the number of employees you have by race and gender in various job categories. And your first report will be due on or before March 31st. So this essentially creates the California version of the federal EEO1. Those reports, they're going to the DFEH, but the DFEH has to make them available to the Department of Labor Standards Enforcement upon request. You're also going to have to maintain these reports for at least 10 years. And it authorizes the DFEH to seek an order requiring non-reporting employers to comply. So a somewhat related bill we'll go to next, AB 979. So this you can think of as a follow-on to the 2018 law that required publicly held corporations with their principal offices in California to have a certain number of women on their board. So now this one requires those same corporations headquartered in California, according to your 10K, to include at least one director from an underrepresented community. And the compliance period for this, I think you have to have, yes, it's by the end of 2021. And then by the end of 2022, the corporation must have at least two, or actually 2 or 3 members, depending on the size of the board. So underrepresented community in this context means someone who self-identifies as Black, African American, Hispanic, Latino, Asian, Pacific Islander, Native American, Native Hawaiian, or Alaska Native, or who self-identifies as gay, lesbian, bisexual, or transgender. Fines for violations of this one are going to be pretty steep. $100,000 for the first violation and $300,000 for each subsequent violation. So one more before I pass the torch. This is AB 1947. This increases the statute of limitations for DLSE complaints. So currently, workers alleging that they were discriminated or retaliated against in violation of a labor commissioner enforced law have 6 months to file a complaint. This bill extends that deadline to a year, 1 year after the violation. And another thing it does that you should know about is authorizes the award of reasonable attorney's fees to plaintiffs who bring successful whistleblower actions. So with that, if any of the other panelists have any comments on any of those, chime in, or if not, I will send it over to Brian.
There is one question, and thanks, Stephen. It's a tough question. I'll read it, and then we'll kind of discuss. The question is, we have California team members working from home. If they get COVID, is that still reportable as workers' compensation? And I think it's as clear as mud. Working in the workplace, we're seeing a lot of these questions arise because, you know, if someone trips over their computer cord in their home office, is that now reportable? And, you know, my advice, and I'm interested if you know, the others have a different take, is if an employee reports to you an injury and they claim it is work-related, then, you know, give them the paperwork to complete the report of first injury. And I think that probably applies. I think folks will be arguing that the home office is an extension of the office. And so if they are exposed to COVID, you know, we're probably better off filing it and seeing what the workers' comp divisions in each of our states actually do with it. And one thing we're not covering is, reimbursement of expenses in California. And I know Dora and I have dealt with this a lot in trying to understand and do with the right thing. But in California, you can basically argue almost any expense that they're going to incur related to the business, i.e. home offices, et cetera, could be, a reimbursable expense. If that's the case, then that home becomes much more an extension of the workplace, and, an exposure at home arguably could fall within then this workers' comp. Now, if the exposure ends up being because a child went to school and came home and exposed the worker around the dinner, table and not in the home office, then I suppose there's an argument that it's not, but I think that's going to have to be sorted out by the workers' comp division. So in my view, the advice is file it.
Sorry, Brian. Were you finished on that one? Okay. There was just another question I wanted to answer, and the question is, did I understand correctly? And you said that we should show on our employees' paycheck the emergency paid sick leave. For example, show a balance of 80 hours and then adjust the balance if the leave is taken. Essentially, yes. What the new bill requires is that the California Labor Commissioner enforce the new COVID paid sick leave as if it constitutes the paid sick leave under existing California law before COVID. So the existing paid sick leave law requires you to provide a written notice to the employee that sets forth the amount of paid sick leave available for use. So you most certainly need to let them know how much they have left in the bank to use with the on a going forward basis. Now, just so you know, some of my clients have struggled with adjusting their payroll systems to show that. You can provide that notice separately, but along with the paycheck statement, particularly where this law is currently in effect only through the end of the year. So before you go through a ton of work adjusting your payroll settings, maybe think about that for a minute. And the other thing on the paid sick leave, the COVID paid sick leave law, is that you are allowed to offset against that 80-hour requirement leave that you're already providing, which covers the same reasons. And those reasons are essentially where the worker is told to stay home under a local, federal, or state quarantine order, or where the healthcare provider advised them to stay home, or where you are prohibiting them from working because you're worried that there may be spread of COVID that's involved. So if you already had leave that covers those situations, you may offset on an hour-by-hour basis, and then there's provisions for how much you have to pay them. So that's a separate issue we can take offline if needed. So I'll stop that and turn it over to Brian.
Great, thank you. We're going to jump forward here on what we're presenting. Some of these questions, because there are just so many, we're covering a lot. We might have to handle offline to keep moving forward. We want to make sure we hit everything that people signed up for. So, all right, we've decided we're going to go to California. Despite all of the frightening fear that's out there, it is fertile ground for businesses. So how do we hire in California? And, unfortunately, it is not that simple. There are a lot of steps that you need to follow, and if you don't, you get tripped up and create, potential penalties and problems for yourselves. So what we've done is and I think these slides will be sent out to everyone, and they will have hyperlinks, as you see here, to the actual forms and documents we're talking about. So let's just walk through, I've got 3 pages of things to consider when you're hiring in California. And this really starts from the start off point, right? Before you have an employee that starts working, you need to take some of these steps. And California's Employment Development Department, the EDD, they manage unemployment, payroll tax, etc. They have that first link before an employee starts. And it's some very helpful information about how you set things up and what you need to do. And primarily that's register as an employer with the EDD and get your employer payroll tax account. The other thing that you need to do within 20 days of hiring your employee is file a report of new employee, this DE34 at the EDD. That's for every employee. So that's an ongoing, as you continue to hire an employee, you need to be putting that form together and submitting that. The next issue here, or the next notice, I should say, is the DLSE, and that's the Division of Labor Standards Enforcement. They have a notice to the employee that generally provides all kinds of information, and that's this form, the NTE form, that you should complete and provide to your employees. It in essence has, you know, the basics: who's the employer, what's the pay rate, etc. Very basic information, but it's a notice that we're required to give to our employees as they begin employment with us. And the next issue here is if you have not been operating in California, then you have to file what's called a Statement of Information with the California Secretary of State. And that is, you know, just a form to show that we're conducting business in California, and we are, you know, here's our information, here's our address. A lot of required information is in this form. And you are required to have a California address for a number of these things, including on this Statement of Information. I quickly am seeing a couple of questions. Is the DLSE notice to employee form mandatory for non-exempt and exempt? Yes, it is for every employee. They don't make a distinction between exempt, non-exempt, because the information provides them what their pay rate is, et cetera. Another question I see is, do you file DE34 reports for partners? I think we're going to have to take that off. I need to understand what you are describing as a partner versus an employee. It is for all employees. So let's jump forward here to the next page. Obviously, you need to get workers' compensation coverage insurance and have that in place at the appropriate levels before you start operating. You need to provide this, again, here's a classic California piece, right? Notice of rights of victims of domestic abuse, sexual assault, and stalking. All right, this is a notice that you provide to your employees that in essence tells them about how they can seek assistance if they're in a situation of domestic violence or sexual assault. Anyway, it's kind of one of these add-on things that you just need to do to comply. The next thing is pay attention to getting any required licenses. This isn't just for business licenses, which you will need, but several industries have their own licensing requirements in California. I've listed a couple of those to be aware of, but again, make sure you have the proper licenses to operate in the type of business that you are conducting. Dora mentioned a minute ago about the payroll and pay stub requirements. You've got to get this set up and have it set up appropriately for California. This is one of those where people get really tripped up, and we are seeing so many class actions come out of this. So there are 9 or 10 specific things that you must have on every paycheck. If you don't, you're going to get slapped with ridiculous penalties. So it's a very simple fix. Make sure you have everything that you need on those. And if you're uncertain, we can certainly help you to understand what you need to include. The next thing is you've got a number of pamphlets and posters that you have to have in place. a number of unemployment insurance, paid family leave, disability insurance. That's one pamphlet and form. You need to have Cal OSHA. You need to have the Department of Fair Employment and Housing, Discrimination and Harassment posters, and notices of COBRA rights. Now, if you're working remotely, you need to have those, I think, in a place that is, that you can show you have notice of providing it, and then where the person has access to it all the time. Moving forward again on hiring, you've got to ensure that you are compliant with California state and local laws. Paid sick leave is one. There's mandatory paid sick leave. You've got the daily overtime and potential for double time. It's not just anything over 40 hours in a week in California. It is overtime is anything over 8 hours in a day, double time if it's 12 hours over in a day. You've got meal and break period requirements. You've got the paid family leave. All of these things require a lot of focus on compliance and make sure that you have checked those boxes, that you're paying people properly, that you're paying them properly on their meals and providing the proper breaks that are required by law. It's a very unique creature in California to be in compliance. Some of the other considerations before we get to termination, confidentiality agreements. You can use those, employee inventions agreements, trade secrets protection. All of those are fair game and should be used in California for certain employees. Restrictive covenants, non-competes and non-solicitations of customers are invalid. They're not just invalid, they are against public policy. That means even if you include them, and I have had a number of folks over the years that include them as a deterrent, that means you are operating illegally in California. And we're starting to see a lot of these cases come out and say, you were operating illegally because you had this in place. I don't care if you weren't going to enforce it. You had it in place. It's illegal. Disgorge your profits for the time that you were operating illegally. That is a huge risk. Don't use it as a deterrent. It's just not worth it. Now, you can have very limited non-solicitation of existing employees. That's still there. It's a little bit gray, but you can still have that. Do not have a no hire. A no hire is problematic, but a non-solicitation of existing employees you could use. Required sexual harassment training. When you're looking at doing criminal background checks, California is a no ban the box. You have to be very careful what you use. Commissions agreements must be in writing. This is another place where people get tripped up because nationally they don't necessarily have that, but they need to have, commissions agreements in writing in California. Exempt, non-exempt differences. There are distinctions in California on the exemptions. And so if you have all employees, you need to make sure that you are treating them as exempt in California and meeting those requirements. I'm quickly running out of my allotted time. I'm just going to jump now to terminations. California is, California is an at-will employer state, so you can have at-will employment. The key here is if the employer terminates, the final pay is due immediately. Okay? It's not 24 hours, it's not 72, it is due immediately. You are also required to provide notice to the employee to a change in relationship, and that needs to be provided by termination. There's a link to a form that is used for the unemployment insurance, which is this notice to employee as to change in relationship. That needs to be provided. The other piece is, again, if we terminate, final pay is due immediately. Unless there's a contract or a collective bargaining agreement that states something different, when the employee resigns, pay is due within 72 hours. Now, a lot of states let you pay it out on your regular payroll, not California. If someone resigns, you've got to pay it within 72 hours. There's also this notice from unemployment for your benefit that must be provided to the employee. If we don't, then we've missed one of those check the box sort of things. So you have to provide that. You also have to provide a notice of all continuation, disability extension and conversion coverage options under all of your employer-sponsored plans. So any of your employee benefits, you have to provide the notice of their continuation benefits that may exist after termination. And then finally, a couple of last things. If you've got more than 20 employees, you have to provide this HIP notice, which is the health insurance premium payment. And there's the form there that we've connected you to. You have to pay out all vacation and PTO. You cannot have this use it or lose it or have someone forfeit that in California. The other piece that you should be aware of is even if you have written authorization to withhold from final pay, there are court cases in California saying you cannot withhold on the final pay. Generally in most states, if you've got some prior authorization, you could do that. In California, courts are saying no, you should not be withholding on the final pay. And then the last thing that I will just note is if you are doing mass layoffs or plant closings, major terminations here, make sure you're compliant with the Federal WARN Act or the California Mini WARN Act. And they have, their own specific provisions and apply to certain types of layoffs. So you need to be aware of that before going into that type of a situation. And then finally, the enforcement of employment agreement. Again, California has the Uniform Trade Secrets Act. So on trade secrets and confidential information, it's not too different from any other state. And you can have ability to enforce related to trade secrets and confidentiality. However, again, non-competes, non-solicits of customers, don't even try it. So with that, I'm going to close that down unless I see some questions over there. I don't know if we want to catch those or just answer them in the chat probably. I haven't been watching all of them. But with that, I think, Greg, you are up next.
Glad to be with all of you today. My name is Greg Salin. I'm a partner in the labor and employment practice in Salt Lake City, and pleased to have this opportunity to be with everyone. I am talking today about independent contractors and the exceptions. You've likely seen a great deal of press coverage this year of all the California changes. This is probably the highest profile of them, that with AB 5 being passed, there was a significant change in how it would be determined whether someone is an employee or an independent contractor. Now, the big hoopla has been with the discussion with gig workers, and particularly Uber and Lyft and the food delivery services and others, where the workers are set up as independent contractors who are getting their work off their phone, using their own vehicles, and being treated not as employees under the systems. It has turned those business models either upside down or into a desperate panic to try to find a way around the law or to have it changed. But there hasn't been as much focus on those outside of being gig workers, and I do want to address that today. This law has significant impact on any businesses in California that are regularly using independent contractors, particularly if those independent contractors are involved in the central function of the business. In other words, doing what the business is in business to do. There is an increased risk there. And we have seen already that significant companies in California have cut ties with independent contractors to avoid the liability, really changing the way that they do business. What AB 5 does, and I get this question from clients from time to time. They call and they say, so you can't have independent contractors anymore in California. And obviously that's not true. If you, hire a company to come in and paint for you, they're going to be independent contractors, and that's still permissible. But the test has changed. And so there was a case called Dynamex in California where the ABC test was adopted. AB 5, the legislation, codified that test. So now, unless you fall within an exception, the AB test is what courts will look at to decide whether someone is an independent contractor or they're an employee. Most significantly, the first prong you see there is control and direction of the person who's doing the work, and that was a mainstay of the law before the ABC test, and is still a primary factor. The second one, however, is a game changer. It is the worker performs work that is outside the usual course of the hiring entity's business. So you think of Uber, for example. Those independent contractors who are out giving rides to customers are in the usual course of the hiring entity's business, and that is an important test. The third one is the worker is customarily engaged in an independently established trade, occupation, or business of the same nature as that involved in the work performed. And what that seems to mean is, where is this worker getting his or her business opportunities from? If it's all from the company, the employer, as the test would determine, then that factor is obviously going to fall in favor of someone being an employee. So unless the hiring entity satisfies all three of these conditions, then the person will be considered an employee and not an independent contractor. And I'll tell you, for years, I've had employees who come and say, well, here's the agreement. It says right here at the top, independent contractor agreement. We've all agreed. Well, those days are long since past. Even when an employee would prefer to be an independent contractor, asked to be an independent contractor, or where it may make no sense at all to even have them working for you unless they're an independent contractor, the law here seems to not care. And so we should take care in looking at independent contractors who are working with our businesses and ensure that we don't have an issue that's coming. Now, I'm excited for everyone to be able to talk about something concerning the upcoming election that has nothing to do with presidential politics. Proposition 22 is on the ballot in California, and I say it as it's an interesting proposition that is being put up to California voters. It is fueled by Uber, Lyft, and other companies, like we've talked about, the gig workers. They've actually put in over $200 million. I believe it is the most highly funded proposition that's been put before California voters in the history of propositions in California. And it is to protect these so-called gig workers from AB 5. Interestingly enough, what it does not do is does not just carve them out. It creates, and this is my wording, this independent employee. It's not a word that they use, but I think it's interesting that they are creating a category that seems to be in between independent contractor and employee. So under California law, they would be independent contractors, but they're independent contractors that have employee-like protections, like a quasi-minimum wage. So that's controversial. Maximum working hours. There are health care subsidies for employees that work a certain number of hours. And then there's access to accident insurance and death benefits. And also interesting, the proposition seeks to give some responsibility to the companies for these independent contractors, giving them anti-discrimination and harassment policies, training for drivers, trying to address some of the violence and sexual assault issues that have arisen, and zero tolerance for drug and alcohol policies and requiring background checks. So a very interesting proposition. And while this may not apply to most of you who are listening here, it is always interesting to see what the law is doing. And I think we all should take plot and watch this Proposition 22 and see what happens. Because if this is successful, that those that would traditionally be found to be employees are now being moved to independent contractor, but with some special protections, are we going to see other employers, other industries say, this makes sense for us? We could hire more people more effectively, more efficiently, if we were to be able to classify them this way. I think this may be a trend that will be interesting to watch. As we all hope, the way California law will affect us outside of California, we all hope not at all, but I think we've seen that sometimes this is the start of a trend. When AB 5 was passed, these were the exceptions that you see here that were built into the law. Physicians, medical professionals, insurance brokers, lawyers, of course, we always protect ourselves, architects, engineers, private investigators, accountants, registered securities brokers and dealers and investment advisors. And then this last category of direct salespeople, we actually have quite a few businesses in Utah that utilize direct sales or so-called multi-level marketing or those setups to use independent contractors who will sell product around the world. Well, those in California have an exception here, which can be important to those companies. Additionally, as David mentioned, just in September, the legislature added a number of new exceptions, as you see I've listed here. And I'll tell you, this is interesting because it shows that the industries that are able to lobby, who have enough influence, seem to be able to get themselves on the exceptions list. I'm sure there's some politics behind that, and certainly the gig workers, you would think that they would qualify there, but have not. But nonetheless, I think any of the industry groups who get together and can come up with a good reason why they should have an exception, I think we will see more of those exceptions to come. Importantly, those that are given exceptions to AB 5 are not just off the hook. That doesn't mean that they're all independent contractors. What that means is that the old law before the ABC test, the Borrello test, named after a California case, is what applies. And you'll see under the Borrello standard, the first question is a matter of control. How much control does the company have over the worker and how they do their work? A traditional question, and in many other states, the primary element of deciding whether someone's an employee or an independent contractor. And then you'll see there are a number of other factors, including some you see in the ABC test, which are secondary factors. And the important thing under the ABC test, it's 1, 2, 3. You've got to meet all three, otherwise the person is an employee. Under the Borrello test, there's a balancing, and these secondary factors, particularly, one might be absent, one might be present, and they can balance and offset themselves, which leaves some level of question as to whether someone is an independent contractor or an employee. Sometimes difficult to tell. Much easier under the ABC test, unfortunately, as the conclusion is often that someone is an employee and not an independent contractor. I say all of this. I think anyone that's doing business in California needs to pay attention to this independent contractor rule. It may influence and impact you in ways you're not anticipating, as you've done business for years with some workers as independent contractors. This appears to be the new exempt versus non-exempt, and we are seeing a tremendous amount of litigation. Plaintiff shops are out trolling for workers, those classified as independent contractors, so that they can file class actions or PAGA actions. Dora is going to talk about those and explain what they are, so I won't do so here. But keep in mind that if you have more than just a couple of these independent contractors, you really run the risk of some significant liabilities from being found to be employees and not independent contractors, but also just the legal costs involved. If you can imagine, if you're treating someone as an independent contractor, it turns out that they're an employee, that's a big problem. You just listened to Brian talk through all of the things one has to do in order to hire someone or fire someone who's an employee. If you go back and you say, well, we didn't do any of that because we thought they were an independent contractor, or we didn't provide, sick days, we didn't provide meal and rest breaks. All of those things can quickly snowball into a rather large action that can be brought, particularly where we have quite a few of those independent contractors. So I encourage everyone just to take a look at your business model and your setup, and if you see that you're utilizing a significant number of independent contractors in ways that they could be classified as employees, it's worth doing an audit and determining best next steps. And I know we're going to run short on time, so I am going to quickly hand things off to Dora so that you will have the benefit of her insights.
Realized that there was another important bill that passed, and that pertains to the amendment of the California Family Rights Act. So for some of you who may have dealt with FMLA issues, FMLA, as you know, stands for Family Medical Leave Act, and that's federal law that generally provides up to 12 weeks for certain qualifying conditions and a little bit longer for certain military leave situations. California has its own version of the federal FMLA, but as you can surmise, it is substantially more protective towards the employee than the federal law is. And one thing I would want to encourage you is to make sure that when you are running FMLA, you're also running CFRA, which stands for California Family Rights Act leave, to the extent though the leave that's being taken qualifies under both statutes, because there are some circumstances in which it does not. Now, the amendment to CFRA under this legislative session substantially broadens the protections again. It used to apply to employers who had 50 or more employees. Now it applies to employers who have 5 or more employees. The requirement under FMLA that the employee work at a work site where at least 50 other employees are also working within 75 miles of each other is now gone under the California version of the statute. Under FMLA, as you may recall, the leave is available for to care for a parent, a spouse, or a child. Under the amended CFRA, the definition of family member also encompasses grandparents, for example, and siblings. So much broader definition of what is covered. So to the extent that you're dealing with leave situations, I just would encourage you to really look at both statutes, because there are some important differences and you need to make sure you're in compliance with both in California. And California under CFRA has its own certification forms, which are less permissive in terms of disclosure to the employer of a medical condition. So again, be sure to use those instead of FMLA forms in California to the extent you're dealing with a medical condition that's involved. Okay, with that, I will stop talking about CFRA. Talk about PAGA. Hopefully you guys have never heard of PAGA ever in your lives and never will, but chances of that are not very high. In fact, Brian and I had a CLE last year, and I recall the presenter at the time said, you know, if you've never been sued on a wage and hour matter in California, you will. If you've been sued on a wage and hour matter in California, you'll get sued again. So that's just the nature of the beast in California. And PAGA lawsuits are extremely popular. So what is PAGA? PAGA stands for Private Attorney General Act, and it's also known as Sue Your Boss Law or the Bounty Hunter Law. It was put into place back in 2004, so it's been on the books for quite some time, and it was established in order to allow private plaintiffs, so individual employees, to essentially step in the shoes of the California Labor Commissioner and seek to pursue civil penalties that otherwise were only capable of being pursued by state law enforcement agencies. So they realized that the California law enforcement agencies are lacking in resources to pursue those claims, so they put the statute in place, allowing individual plaintiffs to pursue. And since then, all hell has broken loose, because these are these types of lawsuits are great opportunities for plaintiffs' lawyers to line their pockets. In fact, I have a potential PAGA suit right now. I was trying to talk the plaintiff into resolving this on an individual basis. And he kind of laughed and he said, I'm a plaintiff's lawyer in California. You know how we make our money, right? So this is the attitude that you're dealing with. But the reason why this is such a problem is because the penalties add up really quickly. So think about every conceivable wage and hour statute in California, and a laundry list of them are deemed to be what's called Category 1 violations. So meal and rest periods, minimum wage, overtime, pay stub violations with some small exceptions. All of these, did you pay on time? How much did you pay on time? Did you properly calculate the regular rate of pay? All of those issues are things that would trigger a potential PAGA penalty. And if there is a violation, no matter how small, the penalties are $100 per employee per pay period for the initial violation, and then $200 per employee per pay period for a subsequent violation. So think about it for a second. If you have 100 employees, and there's a little bit of a difference interpretation, plaintiffs' lawyers always want to interpret this for the initial violation as the first pay period. So if plaintiffs' lawyers have it their way, it's $100 per employee for the first pay period, and then $200 per employee for every pay period thereafter for the 1-year statute of limitations that PAGA uses. So those add up very quickly, could be in the millions of dollars in terms of penalties. They used to be sort of the throwaway claim that every plaintiff's lawyer would put into a class action lawsuit because their bread and butter was really a class action. PAGA is not a class action claim. It's sort of a sloppy class action. It's not subject to class action requirements, so it's much easier to maintain. And more importantly, employers, particularly in the last few years since arbitration agreement cases have come out largely in favor of the employer, employers have gotten smart and are putting in place arbitration agreements. The caveat is that PAGA claims cannot be arbitrated. Under California state law, those stay in court. So that's why they've become so very attractive to plaintiffs' lawyers, is because you cannot force a PAGA claim into arbitration. And just to clarify, the reason why it is attractive for an employer to force a wage and hour claim in arbitration is because typically in those arbitration agreements, we also include class action waivers. So the class or potential class is basically broken up before it even becomes a class, except for PAGA claims, which have to be litigated in court, which have sort of stayed as the for sure avenue for plaintiffs' lawyers to be able to maintain a group action on behalf of other employees. So let me just change. The other reason why PAGA is so very attractive to plaintiffs' lawyers is because there's a relatively limited opportunity to cure. So you may have heard me mention earlier the word Category 1 violations, and those are a long, long list of wage and hour violations that are listed in one part of the statute. There are two other bases for violations. The second basis is statutes related to worker safety, occupational health and safety kind of issues. And then there's the last set of violations, which I call loosely Category 3 violations. Those are other labor code violations, which an employer has typically 33 days to cure, and you have to give notice to the employee and the state and tell them how you cured. And frankly, the cure is very, very burdensome. However, at least you have an opportunity with those certain provisions of the labor code to try to fix it. But the reality is that the vast majority of litigation we see are these Category 1 violations because, A, plaintiffs' lawyers always throw the kitchen sink on wage and hour issues, and B, they know that those violations can be cured. So there's nothing you can do about it if it falls under the particular enumerated statutes. Expense reimbursement, for example, is one of those enumerated statutes can't cure. Another problem with PAGA is it has a very broad definition of an aggrieved employee. Now, if you've ever had a class action lawsuit, hopefully you have not, you will know that one of the requirements is that the plaintiff must have suffered the same type of harm that is suffered by the purported class. Not so with PAGA. So you can have an employee who, let's say, alleges 10 different wage and hour violations. So long as that employee has suffered one violation that that person has in common with a group of other employees that they seek to represent, that's all that they need. These other employees could have 20 alleged violations that are completely unrelated to the plaintiff's 10. So long as there's one that overlaps between the plaintiff and the other group, the plaintiff has standing to bring an action on behalf of these other people. So it is much easier to maintain a PAGA action. As I mentioned, it's not subject to class action requirements, so there's no certification per se. Much, much easier for plaintiff's lawyers to keep it. So here's the interesting part. Plaintiff's lawyers love to bring those. The reality is that 75% of the pot goes to the state and 25% goes to the aggrieved employees. So there was a case I was looking at a few years back. It was some kind of a joke. The settlement amount was about $7 million. And I think the employees, because the group was relatively big, wound up getting like 15 cents per person, something along those lines. And then the plaintiff's lawyers got, hundreds of thousands of dollars in recovery for attorney's fees because PAGA has an attorney's fees provision. So it's easy money for the plaintiff's lawyers if they want to go that route, which is, again, another reason why this is so attractive. We talked about these already briefly, so I'm going to just move on from this one. So what can be cured? We talked about those Category 3 violations, but a relatively recent amendment in PAGA about 5 years ago or so allowed for 2 Category 1 violations to be cured. They relate particularly to wage statements. If you will recall, Brian spoke earlier about the fact that there are certain things that must be on the paycheck, and those certain things are listed in Labor Code Section 226 and some standalone statutes. But a plaintiff's lawyer will submit a request for payroll records, to which you're supposed to respond, by the way, within 21 days of getting it, and they will then literally sit there and go item by item on the paycheck to make sure that you've listed everything. And guess what? If you haven't listed it for that plaintiff, chances are you haven't listed it for anybody else. There goes the PAGA action or the class action if you don't have arbitration agreement in place. So recognizing the abuse, the legislature amended PAGA to allow you to cure 2 types of wage statement violations: the inclusive dates of the pay period and the name and address of the legal entity, that's the employer. It used to be all kinds of cases being brought because the name of the employer was, for example, a DBA, or maybe the ink wasn't showing up on the paycheck or something along those lines. Highly technical violations, which you can now cure. There's a limit of curing those once in a 3-month period, with Category 3 violations 3 times in a 12-month period per violation. But again, very difficult to comply, so hopefully just stay out of it. Doesn't apply to workers' comp claims or generally to posting or filing rules. Oh, we're running out of time. Let me skip over and tell you really fast about unlimited PTO policies. They're all the rage, okay, especially in California, especially when employers are trying to be hip and cool and treat their employees as responsible adults. And we now have a case in California that actually addresses unlimited PTO policies. And surprise, surprise, the case came out against the employer, but not all hope is lost because the court sort of outlined what they may deem acceptable. In this particular case, the ruling went against the employer because, for starters, they did not have a written unlimited paid time off policy. There goes problem number 1. In addition, the evidence showed that the plaintiffs were generally expected to take somewhere between 2 weeks and 6 weeks of vacation per year. So it wasn't truly unlimited. There were some implied parameters that the court read into what was actually going on. And so really quickly, what the court said is you could have an acceptable unlimited time off policy, which would not trigger payout, but there need to be certain conditions. So it has to be in writing, and then you clearly have to tell them that they could take paid time off But this ability to do so is not additional wage for services performed. Rather, it's a part of the flexible working environment that you are providing. So not wages, flexible scheduling. You're supposed to communicate to them so they're clear what their rights and their obligations are. And you're supposed to tell them that essentially by failing to schedule time off, they're leaving money on the table because otherwise paid PTO would have been paid out at termination of employment. You are supposed to allow them enough opportunity to meaningfully take time off. And my personal favorite is this last one, where you're supposed to administer it fairly so it doesn't become a use it or lose it policy or result in equities. So you guys are supposed to monitor the time that people are taking and make sure that it's distributed fairly and equitably. Well, you might as well have a PTO policy if that's how it's going to be. So it sounds good. The court didn't completely come out and say, no, you can't do it, but the practicality of administering this may be a challenge. So keep that in mind. When you think this is such a great idea, just keep in mind the practicality of making this enforceable. So I will stop for now. We're 4 minutes beyond time. Any last minute questions? Would you guys like to maybe stick around a little bit more and have us answer some of your questions, or should we follow up via email? What is best at this point? And by the way, the webinar is being recorded in the event that people can't stay longer. No? Let's see. Okay. Someone said the great question, and that was under the amendment to CFRA changing application to employers with 5 employees. Is there any clarification on whether the employees must be in California to trigger application, or is it 5 total? Not that I saw, and you guys should know that under the Fair Employment and Housing Act in California, which is the state anti-discrimination law, the administrative agency in California has taken the position that even if the 5 employees that are required to trigger state anti-discrimination protections are not located in California, even out-of-state employees count, but they will not be afforded the protections of FEHA. So if I would have to extrapolate, my sense is they will probably try to interpret it the same way.
It's almost any way that California can reach, they will, to find coverage for a California resident or employee.
Right. So, okay. Well, if there are no more questions, thank you guys. Oh, hold on. Are partners, equity and non-equity included the definition of employees in all the regulations presented? So I don't think this is a clear-cut answer, because typically what is reviewed is how much are these quote-unquote partners acting as owners as opposed to employees. How much control does the company have over the partners? How much do they participate in the governance? So this is really a kind of a very highly fact-specific analysis. I'm happy to take that offline if you'd like to explore it further. Any other questions? No? Okay. Well, thank you, everybody, for being with us today. It was a pleasure to be here, and hopefully we could do this again at some point in the future.
Thank you, everyone. Nice to be with you.
Thank you.